Good afternoon and welcome back to the Public Service Commission with the continuation of the hearing in docket number 2021-88E. Hope everyone had a good lunch break. Let's start by taking a roll call of commissioners. Appearing in the hearing room, we have Commissioner Thomas, Commissioner Williams, Commissioner Belser. Appearing virtually, we have Commissioner Irvin, Commissioner Caston, and Commissioner Powers. And on our schedule, I think we are ready for SECIBA to present their responsive witness.
Madam Chair, this is John Burns for SECIBA. We did present.
We did present, Mr. I'm sorry.
It went so quickly, nobody noticed.
No, I am looking at Mr. Searcy's testimony and saying SECIBA, and I need to be calling on Southern Alliance for Clean Energy and South Carolina Coastal Conservation League. I apologize. Thank you.
No problem. Thank you, ma'am.
Vice Chair Belser, we're ready to call Kenneth Searcy.
Mr. Searcy, I'm going to ask the court.
Yes.
I'm going to ask the court reporter to swear you in. It's been a while since we've seen you, I think, and
Sure.
We'll administer the oath today. Madam Court.
Of course.
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please go ahead, Ms. Clancy.
Great. Thank you, Vice Chair. Mr. Searcy, please state your name for the record.
Kenneth Searcy.
And by whom are you employed and in what capacity?
I am self-employed as an independent electric sector consultant.
And Mr. Searcy, did you cause to be pre-filed in this docket on October 8th, 2021, responsive testimony consisting of 9 pages?
Yes, I did.
Do you have any changes or corrections to your pre-filed responsive testimony at this time?
No, I do not.
And if the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes.
Vice Chair Belser, I would move to have Mr. Searcy's pre-filed responsive testimony entered into the record as though given orally from the stand.
Mr. Searcy's pre-filed responsive testimony will be read into the record as if given orally from the stand. Thank you.
Now, Mr. Searcy, did you prepare a summary of your responsive testimony today?
Yes, I did.
Would you please read your summary to the commission?
Sure. Good morning, Vice Chair Belser and members of the commission. My name is Kenneth Searcy, and I'm testifying in this proceeding on behalf of the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. As noted at the last hearing, I'm an independent clean energy consultant with 10 years of experience, during which I have developed expertise in areas such as avoided cost rates, resource planning, asset certification, program and tariff design. Today, I am presenting testimony in response to the report prepared by London Economics International LLC, or LEI, on Dominion Energy South Carolina's 2021 avoided cost application. Though I find many of the conclusions in the LEI report to be justified and reasonable, my testimony explains why I disagree with LEI's conclusions on 2 specific issues. Number 1, natural gas price forecasts, and number 2, seasonal allocation of capacity value under the technology neutral rates. First, with respect to natural gas prices, I note that LEI finds my recommendations for long-term natural gas prices to be reasonable, and they even use the same approach in their own long-term gas price outlook relied on for their report. However, LEI ultimately concludes when comparing my approach to desks that, quote, it is possible to defend either position, end quote, and finds desk's price outlook to be within a reasonable range of potential outcomes. I disagree, and for the same reasons set out in my direct and surrebuttal testimony, continue to recommend that the Commission reject the approach desk used to forecast long-term gas prices. Significantly, the Commission already rejected desk's approach in desk 2020 IRP proceeding in favor of the approach I am currently recommending. And there's no reason for desk to depart from the Commission-approved methodology used in its 2020 IRP when calculating its 2021 avoided cost rates. In addition, I would like to reiterate how deeply dependent desk's methodology is on the particular NYMEX price samples used, and specifically in this case, the 2023 prices. In fact, the movements that have occurred in natural gas futures prices in just the past few months during this proceeding illustrate the effects of this dependency on desk's approach. Since desk sampled NYMEX gas futures prices earlier this year, those prices have risen dramatically, with 2022 futures rising by 55% and 2023 futures rising by 31%. In fact, using the most recent NYMEX prices, desk's methodology actually results in higher gas prices than I recommended in my direct and surrebuttal testimony. The reason is that mathematically applying an escalation rate to an initial price point places tremendous importance on that initial price in terms of the rest of the forecast. Next, turning to seasonal allocation of capacity value, I continue to recommend that the Commission reject desk's proposal to allocate all capacity value to the winter mornings. On this issue, LEI and I agreed that all QFs, including standalone solar, should have access to the technology neutral capacity rates. However, regarding seasonal allocation of capacity value under the technology neutral rate, LEI recommends that desk provide more substantive analysis in future proceedings regarding summer capacity value, while I recommend improving desk's seasonal allocation in the current proceeding. I would like to highlight the practical implications of LEI's recommendation to use technology neutral capacity rates for all QFs while delaying corrections to the seasonal allocation. Because under its current proposal, desk limits capacity payments in the technology neutral capacity rate to a 3-hour winter morning window in which there is little to no solar production. Standalone solar QFs are likely to receive little, if any, compensation for their capacity contributions to the grid, ultimately discouraging solar development. This outcome is problematic because QFs can and do provide capacity value in other times of the year, but will not receive compensation for that value unless seasonal allocation is revised to reflect desk's summer capacity needs. The seasonal allocation approach and results presented in my direct testimony are a reasonable alternative. My analysis used historical data from desk's system to account for the load patterns in the company's service territory, capturing the primary driver of capacity need, while also accounting for the effect of the existing solar capacity already interconnected on DESC's grid. In contrast, DESC fails to offer any substantive support for its proposal to allocate zero capacity value to summer months. Instead, DESC asserts that there's no summer capacity need because of the solar already on its system and excuse me, higher winter reserve margin. But this commission dismissed those same arguments in DESC's 2019 avoided cost proceeding, concluding that, quote, DESC's position that incremental energy supplied by solar QF facilities will not allow it to avoid any future capacity is not reasonable, end quote. In conclusion, while I support LEI's recommendation for additional analysis on this topic in future proceedings, I do not think it is reasonable to adopt DESC's seasonal allocation in the current proceeding. Instead, I continue to recommend the Commission adopt the seasonal allocation proposal in my direct testimony as the most reasonable approach on the record. And that concludes my summary.
Thank you, Mr. Searcy. Mr. Searcy is now available for cross-examination and questions from the commission.
Thank you. Johnson Development Associates.
Good afternoon, Vice Chair. This is Court Walsh for Johnson Development, and we don't have any questions for Mr. Searcy.
Thank
Thanks.
you. South Carolina Department of Consumer Affairs.
This is Roger Hall. No questions. Thank you.
Carolina's Clean Energy Business Association.
John Burns for CC, but no questions.
Pine Gate Renewables.
Lan Holman for Pine Gate Renewables, no questions. Thank you.
Office of Regulatory Staff.
Good afternoon, Madam Vice Chair. This is Chris Schubert for ORS. We have no questions for Mr. Searcy. Thank you.
Dominion Energy.
Vice Chair Belzer, this is Chad Burgess on behalf of Dominion Energy. We have no questions of this witness.
Commissioners. Commissioners. Hearing none, Mr. Searcy, you're going to escape this afternoon, sounds like. No cross.
Okay.
Thank you for your testimony today, Mr. Searcy. You may step down. You're excused.
Thank you, Vice Chair Belzer.
Okay. And I think that's all the responsive testimony from interveners. So I think we're back to Dominion Energy.
Good afternoon, Madam Chair. We would call to the witness stand at this time Mr. Eddie Folsom. Mr. Folsom, if you would turn on your camera, there you are. And Madam Chair, I presume you would want to swear in Mr. Folsom.
Given the lapse in time, I think we are re-swearing. So, Madam Court Reporter, would you administer the oath to Mr. Folsom, please?
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Folsom, please state your full name for the record.
John E. Folsom, Jr.
And by whom are you employed and in what capacity?
I'm employed by Dominion Energy South Carolina Incorporated as a senior market originator.
And in connection with this proceeding, I believe you have previously pre-filed both direct and rebuttal testimony. Is that correct?
That is correct.
And have you also pre-filed responsive testimony?
Yes, sir, I did.
And I believe that responsive testimony consists of 5 pages. Is that correct?
That is correct.
If I asked you the questions that appear in that pre-filed testimony, a responsive testimony. Would your answers from the stand today be the same?
Yes, they would be the same.
Madam Chair, we would move the introduction into the record, the responsive testimony of Mr. Folsom as if given orally from the stand.
Mr. Folsom's responsive testimony will be entered into the record as if given orally from the stand.
Thank you very much, Madam Chair. And Mr. Folsom, have you prepared a summary of your responsive testimony?
I have.
Please deliver that at this time.
Good afternoon, Madam Chair and fellow commissioners. In my responsive testimony, I note that LEI agrees with DESC's proposal to increase the amounts of insurance coverage in the form PPA. I point out that LEI also supports DESC's recommendation to adopt the proposed form of surety bond for the standard offer and the form PPA. LEI draws upon its experience in the marketplace to conclude that they do not believe the proposed changes to the surety bond would make surety bonds more difficult to obtain in the marketplace. This experience aligns with the experience of DESC's parent company, which has utilized this form for years. Finally, I respond to LEI's recommendation that the Commission maintain the existing language in DESC's NOC form related to site control. I reiterate that DESC revised this language as a result of certain best practices outlined in FERC's Order Number 872. Although there are differences between Order Number 872 and LEI's position on this issue, they both reflect a general consensus that QFs must show a substantial commitment prior to locking in avoided cost rates pursuant to a LEO. I thank the Commission for its time, and this concludes the summary of my responsive testimony.
Thank you very much, Mr. Folsom. If you would, please answer any questions that the parties or the commissioners may have.
Johnson Development Associates?
No questions for this witness, Madam Vice Chair.
South Carolina Department of Consumer Affairs?
No questions, thank you.
Carolina's Clean Energy Business Association?
Madam Chair, this is John Burns for Carolina's Clean Energy Business Association. I do have a few questions for Mr. Folsom.
Please proceed.
Good afternoon, Mr. Folsom. Can you hear me okay?
Yes, sir, I can hear you just fine. I hope you can hear me.
I hear you fine. Thank you, sir. Just wanted to touch base on a few of the things that you mentioned in your responsive testimony. On the bottom of page 2 of your pre-filed testimony, you discuss the insurance amounts and state that, quote, these increased coverage amounts mitigate risk for DESC's customers, particularly given that these emerging technologies can present increased costs and potential safety concerns. Did I read that correctly?
Yes, sir, that sounds correct.
Nowhere in your testimony, however, do you identify what those potential safety concerns are, do you?
No, sir, not specifically.
And you do not make any connection between those safety concerns and any risk to Dominion's ratepayers, do you?
I don't make a specific connection, no.
Okay. You also note in your responsive testimony, and I'm referring to page 3, around line 12 or 13 of that page, you note that the changes that you proposed to the surety bond requirements, such as removing the surety's chance to raise defenses, quote, aligns with Dominion Energy's experience. Is that correct?
That is correct.
And by Dominion Energy here, you don't mean DESC, you mean DESC's parent company. Is that right?
That is correct. We are fully integrated with Dominion Energy now as Dominion Energy South Carolina. So we no longer have our own risk management group here in Columbia. We are part of Dominion Energy, and we utilize the central services that Dominion Energy provides to all their subsidiaries.
Okay. Do you know if Dominion's unregulated renewables development arm favors the changes that DESC proposes in this proceeding?
I do not know.
Have you ever been employed by a firm that issues security bonds?
I have not.
Have you ever been employed by a
lifelong Dominion Energy South Carolina employee?
Thank you. I didn't mean to talk over you there, Mr. Folsom. Sorry about that.
Quite all right.
Have you ever been employed by an independent non-monopoly company that obtains security bonds? And if you've been a lifetime employee of Dominion, I assume the answer to that is no.
That's correct. I have not been.
All right. Turning to the NOC form language about site control.
Would you allow me to make a comment on the surety bond before we move forward?
Certainly.
just to talk a little bit about the surety bond and the risk that we're trying to mitigate relative to our ratepayers and customers' interests. The reason that we are moving away from the rights of the surety to protest whatever may be the issue of the call on the bond is the thought process that normally when you get to a point with a PPA like the ones we're contemplating in this docket where we are required to or have to draw on a surety bond, you've probably reached some sort of a very severe situation in terms of the status of the PPA, even to the point of the seller being in default. So the general thought process is it just doesn't make sense for those customer protections that are put in place for just those types of scenarios to be delayed by any sort of third-party intervention in that scenario.
You're familiar with the concept of a letter of credit?
I am.
And wouldn't a letter of credit be able to be called upon without defenses?
It would be.
But a surety bond generally is not, is it?
The form of surety bond that we're providing does not allow those defenses, and it was the opinion of LEI that that form of bond was not unusual in the market and would not, cause any significant harm to the developers that would be attempting to utilize that bond.
The form of bond that's been utilized by DESC to date does include those defenses, doesn't it?
That's correct, it does.
And I believe you testified during the last hearing that you were not aware of any instance where Dominion had called upon a surety bond and had that call rejected.
That's correct. We don't have any specific catastrophic type scenarios to point to, but these changes are being offered in the spirit of continual and ongoing attempts to improve our risk management processes.
Thank you. Have you been able to say what you wanted to say on that?
Yes, sir, please. Well, I appreciate the opportunity to talk.
No problem. Looking now at the NOC language on site control, I'm looking at page 4 of your testimony. LEI recommends keeping the existing language regarding site control for establishing LEO, doesn't it?
That is what they recommended.
And the existing language favored by LEI in the NOC form says that a seller must attach documents that simply establish, quote, that the seller has secured control of the project site for at least the length of the delivery term, right?
That is correct.
And they also note, and if we need to look at LEI's report, I can give you page numbers, but they note that this language was approved in the 2019 avoided cost proceeding and, quote, was thus deemed to be commercially reasonable, right? On page 26 of the report.
I would agree with that in terms of the timing of it being approved in the 2019 proceeding.
And LEI notes that this language aligns, quote, exactly with language in the NOC form approved in the equivalent 2019 avoided cost proceeding for the 2 Duke subsidiaries. Do you recall that?
I do recall that.
And they agree with Mr. Levitis's observation that, quote, securing permits and approvals is a condition for achieving commercial operation as dictated in DESC's standard offer and form of PPA, correct?
That is what LEI reported.
And LEI states that it, quote, sees no compelling reason to adopt the changes proposed by DESC. The original language regarding site control was approved in the 2019 avoided cost proceeding and strikes a reasonable balance between protecting customers by ensuring QFs demonstrate a sufficient commitment to seeing their project through while not subjecting QFs to unreasonably onerous requirements. Do you agree that that was LEI's conclusion?
I do.
So LEI recommended that the commission reject DESC's proposal to require that all permits be obtained to obtain a LEO. Isn't that correct?
That is correct. That was their recommendation.
But you testify that such a change should be made because under Order 872 of FERC, utilities, quote, can require that the QF has taken certain actions within its power to obtain site control. Is that right?
Yeah, that is correct. And to put a little more color on that, the changes that we proposed in subsections 4, Roman numeral 3, 4, Roman numeral 4, were intended to be a good faith effort to incorporate some more recent guidance from the FERC in terms of various parameters and conditions that could be used to establish and document that a substantial commitment had been made by the developer to establish a LEO. And both of the items that we laid out were listed out as options that could potentially be required. And so we crafted that more recent language into our proposed form and put it before the commission for their review.
Thank you, sir. I'm going to ask everyone's indulgence for just a second because no one informed the city of Raleigh's recycling trucks that we were having a hearing right now. So just bear with me for a moment. Otherwise, you're going to hear some beeps in just a second. Think they're done. Sorry about that. Order 872 does not require this commission to make that change or the changes you suggest, does it, Mr. Folsom?
That's correct. It's not a required change. They are simply recommended changes that could be used.
Are you aware, sir, that Order 872 is under appeal to the Ninth Circuit Court of Appeals?
Yes, sir. I was aware of that.
Now, you quote FERC Order 872 in your testimony as saying that its LEO provisions, quote, should encourage development of QFs, correct? That's on page 4 of your testimony?
That's correct.
And an LEO is a unilateral commitment to sell output to the utility at the avoided cost rate, correct?
I would agree with that definition.
It's not a commitment to build a project with a specific footprint and design, is it?
You know, that's an interesting question because, you know, it almost seems like it's, you know, which comes first, the chicken or the egg there to some degree, because if you're going to be far enough along with a project to be able to execute and commit to that notice of commitment to sell form based on the required timelines and the obligations that are laid out in that form for both the developer and the utility, it seems to me that you have to be at some reasonable level of maturity in your project to even be able to fulfill the obligations of the NOT form.
So some reasonable level of maturity, does that mean that you need to have a final footprint and specific design of the project to turn into, for instance, zoning or permitting authorities?
I don't know that I would go as far as to say that it has to be absolute and final, but I would think that you would be pretty far along in that process so that as you're starting to think about making expensive purchases of long lead time equipment, and making other commitments that require significant financial commitment, that you would be in a position to do those things.
Gotcha. But it's not possible to get a construction permit before a project's final footprint and design are known, is it?
It's not possible to get one or not possible to apply for one?
Not possible to get a construction permit.
Okay. Well, I believe our proposed language there did not contemplate actually receiving permits. It contemplated the application for and payment of associated fees.
I agree with you there, sir, but doesn't it make sense that you would have a final permit and a final design before you apply for your permit unless you want your application rejected?
That I cannot answer with certainty, Mr. Burns, because I don't work on the construction side. So the exact timing of how those things would work is outside of my realm. But I will say, and I think I said this last time that I was testifying, that, you know, we place a lot of confidence in what the FERC recommends. And so we feel that if the FERC recommended that as a legitimate litmus test, that those types of things have been considered.
Okay. Appreciate that. Have you ever, in your position with Dominion or otherwise, ever been in a position to finance a QF facility?
No, sir. I have never worked on a financing project.
Okay. And you heard Mr. Levitas, the only QF developer to testify in this proceeding, say that your proposed site control changes would be a barrier to legally enforceable obligation formation. Did you hear that testimony?
I do recall that being in his testimony.
Okay. All right. I've got no further questions for this witness, and I appreciate your time, Mr. Folsom. Thank you.
Thank you.
Pine Gate Renewables.
Madam Chair, this is Bland Holman for Pine Gate Renewable. We have no questions. Thank you.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
This is Emma Clancy. No questions for this witness.
Office of Regulatory Staff.
This is Chris Huber for ORS. We have no questions for Mr. Folsom. Thank you, Madam Vice Chair.
Commissioners. Commissioners.
Vice Chair Belzer,
Commissioner Williams.
thank you very much. Mr. Folsom, thank you for being here. Appreciate your testimony on the various procedures and forms and the desire to, the way that Dominion Energy South Carolina is growing and conforming within Dominion Energy overall. On the notice of commitment form, there was testimony by Mr. Levitas about using the idea of using just appropriate zoning to allow a solar array or battery storage. Did you consider that after that that testimony earlier in this case?
We didn't spend a significant amount of time reviewing that, but our general stance on that would be more along the lines of, just the mere zoning status of a particular piece of property really doesn't add a whole lot or go very far in terms of determining site control and the ability to move forward with the project.
But from a permitting perspective, it certainly.
Oh, yes. If it was already zoned, appropriately for that type of project, that certainly would move the process further along right out of the gate. I apologize. I misunderstood your question.
Okay. Are you aware of any research that's been done by the state regarding zoning and solar arrays?
No, ma'am. I'm not personally aware of any specific research along those lines.
Or battery storage? Okay. Thank you. No further questions.
Commissioners, any further questions? Any redirect?
Madam Chair, we do not have any redirect.
Thank you. Mr. Folsom, thank you for your testimony today, and you may stand down and be excused.
Thank you, Madam Chair.
Mr. Willoughby?
Thank you, Madam Chair. We would call next to the stand Mr. Danny Cassis. Would you turn on your camera, Mr. Cassis? There you are. And Madam Chair, I presume you're wishing
Yes,
to
sir.
have Mr. Cassis sworn as well.
Yes, sir. Madam Court Reporter, would you swear Mr. Cassis, please?
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please state your full name for the record.
Daniel F. Cassis,
And by whom are you employed and in what capacity?
Dominion Energy, South Carolina. I'm the General Manager of Strategic Partnerships and Renewables.
In connection with this proceeding, Mr. Cassis, I think you previously provided both direct testimony and rebuttal testimony. Is that correct?
That's correct.
And today you're prepared to submit responsive testimony. Is that correct?
That is correct.
And I believe your responsive testimony consisted of, hold on one second, let me look at it here. 7 pages. Is that correct?
It's correct. It's 7 pages.
If I asked you the questions that appear in the pre-filed responsive testimony, would your answers today from the stand be the same?
They would.
Madam Chair, we would move into the record the responsive testimony of Mr. Cassis.
Mr. Cassis's responsive testimony will be entered into the record as if given orally from the stand.
Mr. Cassis, have you prepared a summary of your responsive testimony?
I have prepared a summary.
Please deliver that at this time.
Good afternoon, Madam Vice Chair and fellow commissioners. In my responsive testimony, I first addressed LEI's suggested standard of transparency. LEI described DESC as highly responsive. LEI then suggests that transparency should be judged primarily by whether the filings minimize the need for interrogatories. This standard is not mentioned in Act 62 and would be impractical to implement. For example, although DESC believes LEI was transparent in this docket, even LEI received multiple discovery requests from other parties. DESC believes this information sharing through discovery is a sign of a healthy docket, not evidence of a lack of transparency. DESC maintains that it exceeded the applicable standard of transparency within Act 62. LEI states, pursuant to PURPA, ensuring DESC's avoided cost rates do not result in the overpayment of QFs should be a key objective of this docket. DESC agrees with LEI on this point. LEI's observation is also evidenced by Act 62 and the FERC's recent PURPA reform efforts. For example, Act 62 mandates that the Commission establish accurate avoided cost rates in this proceeding. The FERC recently discussed the consequences of inaccurate avoided cost rates and found that over and underestimations in avoided cost have not necessarily balanced out, and that in those cases, customers are essentially subsidizing QF generation in violation of PURPA. In this respect, LEI and DES appear to agree that the Commission can protect DESC's customers in part simply by setting accurate avoided cost rates. Finally, I note that LEI's discussion of the RFP process is outside of the scope of this docket, but it appears that LEI and DESC agree that PURPA is not the appropriate mechanism for utilities to add renewable generation in response to an identified need. PURPA allows QFs the ability to force DESC to purchase power, whether a need actually exists or not, provided the cost is at or below DESC's avoided cost. However, an RFP is not a standing obligation like PURPA, but rather is a process built around the needs identified in a utility's IRP. LEI rightly recognizes this concept and the distinction between purpose function and the purpose of an RFP. This concludes the summary of my responsive testimony, and I appreciate the Commission's time.
Thank you, Mr. Cassis. Madam Chair, are the witnesses available for questions from the parties and from the Commission?
Thank you, Mr. Willoughby. Johnson Develop Associates.
No questions for this witness. Thank you.
South Carolina Department of Consumer Affairs.
No questions, thank you.
Carolina's Clean Energy Business Association.
John Burns for CC, but we do have a few questions for Mr. Cassis. It shouldn't take long, Madam Chair.
Please proceed.
Good afternoon, Mr. Cassis. Can you hear me okay?
Yes, Mr. Burns, can hear you fine. Thank you.
Great. I hear you too. So let's get rolling. In your testimony that you just submitted on page 3, lines 16 through 18, and I'm going to share so we can look at the same paragraph, if you don't mind.
Yep.
I've posted page 3 of 7 of the responsive testimony of Daniel Cassis. That's you, correct?
That's correct. Mm-hmm.
All right. On lines 16 through 18 of your testimony, you disagree with LEI's claim that transparency should be judged, quote, primarily on whether the application was presented in a way which minimizes the need for interrogatories in the first place, correct?
That's correct.
You claim that, and you say it here, this standard is not rooted. Well, I'm trying to highlight, but I'm having trouble. This standard is not rooted in Act number 62 and ignores the purpose of discovery. As such, it could lead to unintended consequences, correct?
That's correct.
And am I right that you drop footnote 4 there as an example of unintended consequences, that interveners seeking to discredit DESC's transparency would be incentivized to issue discovery requests when they otherwise may not issue such requests? Would you agree that Act 62 requires that the utilities avoided cost filing be transparent?
Good. You're good. I'm good.
That its filing be
I'm
transparent?
sorry, somebody's.
I'm sorry, somebody is not muted and
Mr. Neely?
if you're not Mr. Burns, Mr. Willoughby, or Mr. Cassis, please, mute.
We're good. I think that was Mr. Neely getting ready to testify and not realizing the mic and the camera were on. So I'll repeat the question, Mr. Cassis. Would you agree that Act 62 requires that the utilities avoided cost filing be transparent?
I think the act says that it should be reasonably transparent. I think that's the standard or what the statute actually says.
And it says that the filing must be reasonably transparent, correct?
It says
I can call it up if we need.
Yeah.
It is in Act, I'm showing it on the screen now, 5841-20 sub J. Each electrical utility's avoided cost filing must be reasonably transparent so that underlying assumptions, data, and results can be independently reviewed and verified by the parties and the commission, correct?
That's correct.
All right. When was DESC's filing in this case?
So the filing, I believe, was in the original filing. We had to file application, and that application was filed in accordance with the commission's required dates. I believe it was in April. It was in late April.
And then the commission found that original filing to be deficient, didn't it?
So what they did is the commission, we made a filing that was not clear information as to what we should file. We believe we were filing what would have been normally filed, the same thing we filed the previous year or 2 years ago, and the same way we filed for fuel. So we file an application, and then after that, we file the appropriate testimony and all the data and provide that as soon as we get it.
But the commission found your filing to be deficient, didn't it?
I don't know. I don't remember if they found it to be deficient, but I know that we agreed that because one of the issues with the filing and the application is that the data wasn't even available. So as soon as we had data that was available, then we provided that data to the commission and to anybody who then requested that information.
And Dominion, DESC has actually made multiple filings in this proceeding, hasn't it? Multiple revisions to that application, correct?
Again, as soon as, in the spirit of being transparent and being reasonably transparent, we are providing every bit of information that we have or that an intervener has asked for in discovery. So
and I guess it's
transparent, yes.
So it's convenient then that the commission ordered you to do that because you were going to do that anyway? Is that what you're saying?
Yeah, we were going to do it. We were clearly going to follow the act, yes, in terms of providing information and being reasonably transparent. That's correct.
And CCBA was actually permitted to file supplemental surrebuttal testimony because even up until the last minute, Dominion was making changes to its testimony, wasn't it?
Again, the company has been reasonably transparent. We are going to provide information. We believe it's appropriate if we make changes to provide that information. So it's not an opportunity for us to hide information. That information is shared with the interveners upon request, or as soon as we get it and data becomes available.
Well, when you say that LEI's transparency standard could have unintended consequences, like encouraging parties to file discovery requests simply to discredit DESC's transparency, are you telling the commission that you think it is a better practice to make an untransparent filing because making a transparent one would cause baseless discovery requests?
No, not at all. What I'm referring to is if LEI's standard is that you're trying to minimize the amount of discovery requests, then there's almost no way for an applicant to know what someone wants to see. We'll provide everything that's reasonably transparent. We'll provide every piece of information we think, But most of the people filing or providing the information, they do not know what an intervener is looking for. For instance, if Mr. Neely's providing information or data, he doesn't negotiate commercial terms. He wouldn't know that an applicant was looking for something, for instance, that might improve their financial performance, in terms of financing a facility. He wouldn't know that.
Mr. Cassis, Dominion DESC is represented by counsel, experienced counsel in this case, aren't they?
We have counsel. We have good counsel. Yes, sir.
And you've got in-house lawyers who help assemble these applications too, don't you?
We do.
So the fact that one of your witnesses may not know everything that would be needed to be disclosed in other areas of the application should be handled by somebody who knows how to consolidate the entire application, right?
Yeah, I think you're missing the distinction on the, I guess my point with respect to LEI. I think that, when they set the standard to say it should minimize the amount of discovery, and all we're saying is that there's going to be a certain amount of discovery, and that is actually appreciated. And we have no problem providing whatever information is requested, but we're not going to be able to predict everything that an intervener is going to want to look at. I think it's been clear that the complexity of the avoided cost calculation is just what I said, complex. So there's a lot of information that would have to be looked at. And
you understand, don't you, that the numbers of interrogatories are limited by commission rule?
The number, yes, but not the number of questions.
So you would suggest then that it's appropriate for interveners to need to use up their interrogatories asking for basic information and calculations rather than using them to drill into specific questions after that material has already been disclosed?
No, that's not what I'm saying. Is that they're welcome to ask for whatever data they need to appropriately, vet their positions or ask what they need to. But just to have the standard is set in the law, which is in Act 62, which is to be reasonably transparent, which I believe we've done in this case.
I think I understand your testimony. Thank you. On page 4, in lines 18 through 19, you state that you quote the FERC order number 872, which has been discussed earlier in this case. You quote the FERC order and you say that FERC order found numerous instances where overestimates and underestimates of avoided costs have not balanced out, and that ratepayers bore the brunt of those overpayments. Is that a fair reading of your testimony?
That's correct.
Do you know that the FERC order 872 is on appeal?
Yeah, I just heard you mention that under the examination of witness Folsom.
Okay. Do you know whether that appeal includes a challenge to FERC's finding regarding these long-term contracts?
I do not know whether the appeal actually looks at that particular finding.
Okay. FERC found, I guess, both overestimates and underestimates in Rule 872, in Order 872. Is that right?
I think what in 872 they found that they haven't balanced out over time, that the estimates actually haven't balanced out over time, is my understanding of the findings.
They say the overestimates and the underestimates don't balance out, but that there are examples of both. Is that right?
Yeah, there are. They just haven't balanced out, which would end up being an overpayment by consumers.
And do you know if the overestimates coincided with unprecedented reductions in natural gas prices due to the adoption of fracking technology?
I wouldn't necessarily know, I guess, what the findings were in 872. I just know that they balanced out. So what they've done is they've actually, ended up in overpayments.
So you haven't actually read 872?
I have not read 872 completely, no.
Okay. Can you tell us what has happened with natural gas prices in the last 6 to 10 months?
Prices are up, but and I don't know whether they'll continue to be up or whether they'll decline. I think there was very good discussion by LEI on that topic.
Okay. Would you accept, subject to check, that since January 1, 2021, Henry Hub gas prices have increased from $2.38 per million BTUs to $5.68 as of October 1st?
In a short period, gas prices can go up and can go down. I would not take objection to that, I would be subject to check. Yeah.
Okay. Did DESC's gas forecast anticipate this rapid escalation in gas prices?
I'm not a gas forecaster,
Okay.
Mr. Burns, but I don't know. Again, I would just say our forecasters are the techniques they use to forecast are well founded, and I think they speak for themselves.
Well, think with me on this one. Would an avoided cost rate that is premised on gas prices being lower than they are result in an underpayment to QFs?
So I think it depends. If you're going to set avoided cost and you're going to set them on a short-term avoided cost, then yeah, there could be a differential. I think it would depend on, again, the term of the contract. So for instance, if it's a 10-year term and avoided cost was inappropriately set higher, you would end up with overpayment depending upon what happened ultimately in the market.
Is it true that setting avoided cost rates too low can stymie QF development?
I don't think I wouldn't use the word stymie. What I would say is that if setting avoided cost accurately, which is what we're supposed to be doing in this proceeding, if they're set accurately, then they would be compensated for what the QFs would actually avoid.
And if the avoided cost rate is too low, then they would be not compensated for what they actually avoid. Isn't that correct?
But which is why we spend a lot of time ensuring that we want to set accurate avoided cost rates. You don't want to set them too high or too low. You want to set them accurate. I think LEI had an appropriate discussion about accuracy and why you want that.
Well, if QF projects are not built, then those projects can't help ratepayers avoid the risk of gas price spikes like the one we're in now, can they?
And they also can't overcharge consumers if there's a differential in the other direction either. I don't think we're trying to stymie QF development. All we're trying to do is to appropriately set avoided costs accurately, so then that QF, if they decide to provide power through a mandatory purchase obligation mechanism, then we would pay the right cost. We would pay the accurate costs.
Thank you, Mr. Cassis. I have no further questions. Appreciate your time.
Okay, thank you.
Let's see. Pine Gate Renewables.
Madam Chair, this is Blanton Hallman for Pine Gate Renewables. We have no questions. Thank you.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
This is Emma Clancy. No questions.
Office of Regulatory Staff.
This is Chris Huber for ORS. We have no questions from Mr. Cassis. Thank you, Madam Vice Chair.
Commissioners.
Vice Chair Belson.
Commissioner Caston.
Good afternoon, Mr. Cassis. Can you hear me well?
I can hear you, Commissioner. Yes, sir.
Good. Relative to transparency, I believe I sense a desire by DESC to have a transparent process. Is my sense accurate?
Your sense is absolutely accurate. We want to provide as much information
so
we possibly can so that we can share it with the commission and with interveners.
Good. Thank you. Do you believe it would be beneficial for
Commissioner, I can't hear you.
Commissioner Caston,
I apologize. I bumped it by mistake.
Okay.
Did you read my lips?
I was trying to, Commissioner.
the court reporter cannot.
I'm sorry. I apologize. Do you believe it would be beneficial for Dominion interveners, customers, Public Service Commission and others to use a more robust stakeholder process in future proceedings to maybe help ameliorate or have less, I guess, adversarial proceedings.
You know, I don't necessarily believe the proceeding is adversarial. I think it actually, I think there's going to be first of all, I think we have to trust each other that we're both looking for the answer. Like in, for instance, this proceeding, I think we both want accurate, avoided costs. And I think that the fact that we're engaging, you know, this is, I guess, avoided cost number 2 that I've participated in. And as we go through, and we would do one presumably in 24 months, we would have a better understanding of what we can do to even be better in what we make or put in our application. And I think interveners would probably have gleaned some of the same insights that we have too.
Okay, and I agree. Let's say it's not adversarial, but I guess to help the process forward, and maybe you answered it, but do you believe if a more robust stakeholder process was used, that it would be better for everyone to accomplish the task?
You know, I agree that stakeholder process is good, as long as it's as both parties are communicating, and I think kind of representing their positions, but there's helpful respect for each of the positions. I think as long as that standard's in place, then that type of process can be beneficial.
Good, because it's good to hear that. Thank you, Mr. Cassis, and I have no more questions.
Any other commissioners with questions?
Madam Vice Chair,
Commissioner Urban.
thank you. Mr. Cassis, good to see you, sir. Can you hear me okay?
Commissioner, can hear you fine. Thank you.
Thank you, sir. I was curious to know, was there any stakeholder process in this docket?
So in this docket, there wasn't, as you know, I guess concurrently with this docket, there was the work around the IRP, which included many of the same stakeholders, and although the topics aren't, you know, perfectly interrelated, they are in that the IRP and ultimately in the supply plan helps determine avoided cost. So I would describe that as meaningful interaction with most of the stakeholders. Not all. I probably shouldn't be lost on this commission that although trade groups represent you know, individual developers have a healthy dialogue you know, with my group, specifically myself and Eddie Folsom, from the standpoint of developing projects. Those are ongoing conversations with individual developers. They may be represented, for instance, by SECIBA, but they're coming to us individually to talk about price discovery and assumptions, et cetera. So although I wouldn't describe that as broad and stakeholder, they're individual stakeholders that we have a decent amount of interaction with.
Well, that's good to know, and I agree with others that a more robust stakeholder process might help resolve some issues prior to hearing. I would hope that that would be the case, and perhaps narrow the focus of the proceeding. And I would encourage your group to consider that, if you will. One other question I had as it relates to the rising pricing on natural gas. As I recall, a few years back, Dominion eliminated or stopped using their hedging program. In hindsight, do you think perhaps might have been a good tool in toolbox to have, considering the rapid increase in natural gas prices this past year?
Yeah, Commissioner, I'm probably not qualified to answer the fuel hedge question. So I'm going to have to respectfully say I probably don't know the answer. I will just concede that we're having a blip right now in fuel prices, but I've seen natural gas prices, I guess, over 30 years. So I've come to appreciate that they do go up and down, and also appreciate the fact that recently at least historically, they've been lower. So I think that's, someone else is probably better suited to answer that question than I am.
Who would that person be with DESC?
The planners that are following me are probably have some expertise, and Witness Neely or Witness Bell probably would be qualified to speak on gas pricing.
Thank you, sir. No further questions.
Commissioners, anything further? Commissioner Williams?
Thank you, Vice Chair Belzer. Good afternoon, Mr. Cassis. Good to see you.
Yeah, good to see you, Commissioner.
I want to ask a question that you may need to refer to someone else. I'll give you that as a heads up. But with all the discussion about transparency, I went back in my notes to some discussion about order number 2020-244, in which I think I recall, or my notes say that the commission, which preceded the current commission, expects and requires a much more detailed and transparent analysis concerning the seasonal and hourly value allocation for solar generation in the next avoided case. And it's my understanding this is the next avoided case. And was that information shared?
So you're right in that I'm not going to be able to answer your question, but fortunately we do have Witness Neely,
okay,
who does or really supervises the analysis, and then also works with the attorneys to provide the data. So he would be able to more, I think, fully answer that question.
Thank you. I appreciate it, and I appreciate your telling me who to ask the question of.
Okay.
No further questions.
Any further questions? Hearing none, any redirect?
Madam Chair, no redirect. We would ask that the witness be excused.
Mr. Cassis, thank you for your testimony today. You may stand down, and you are excused.
Thank you.
Mr. Willoughby?
Mr. Green will call the company's next witness.
Mr. Green?
Thank you, Madam Chair. We call Jim Neely to the stand, please.
Mr. Neely, please be sworn in by the court reporter, please.
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Mr. Neely, can you hear us? Because we can't hear you. Mr. Neely? Mr. Green, can you communicate with him?
We are trying to right now. Could we, maybe it'd be appropriate to take a very short break, Madam Chair?
That's fine. Let's take a 10-minute break. We will return at 2:40.
Thank you, Madam Chair.
Good afternoon. We are back on the record. Let's take a roll call of commissioners, please. In the hearing room, we have Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Belser, and virtually we have Commissioner Urban, Commissioner Powers, and Commissioner Caston. And on the witness stand, we have Mr. Neely. Can you hear us now?
I can hear you. Can you hear me?
Yes, sir. Mr. Green, please proceed.
Thank you, Madam Chair. Before I begin, did we complete the oath, or does the court reporter need to finish the oath?
Thank you very much. It dawned on me as soon as I cut my mic off that we do need to do the oath. So, Mr. Neely, please prepare to be sworn in by the court reporter.
If you'd please raise your right hand. Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Neely, please state your full name for the record.
James Neely.
And by whom are you employed and in what capacity?
I'm employed by Dominion Energy South Carolina as a energy market consultant.
And in connection with this proceeding, Mr. Neely, did you prepare and cause to be filed responsive testimony consisting of 6 pages?
I did.
Are there any corrections or changes to be made to that pre-filed responsive testimony?
No, there is not.
Mr. Neely, if I asked you the questions that appear in your pre-filed testimony, would your answers today from the stand be the same?
Yes, they would.
Madam Chair, I would move the pre-filed responsive testimony of Mr. Neely into the record as they're given orally from the stand.
Mr. Neely's pre-filed responsive testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. Are there any exhibits attached to your pre-filed direct testimony or your pre-filed responsive testimony, Mr. Neely?
No, there is not.
Mr. Neely, have you prepared a summary of your pre-filed responsive testimony?
I have.
Please deliver that at this time.
Good morning, Vice Chairman Belser and members of the Commission. My name is James Neely, and I'm an energy market consultant for Dominion Energy South Carolina. In my responsive testimony, I discussed the recommendations in the independent report on Dominion Energy South Carolina 2021 avoided cost proceeding prepared and submitted by London Economics International. I discussed the recommendations that the company should use a 66 megawatt change in capacity for calculating avoided cost, that it should use the EIA cost assumptions for Aero CTs instead of its own data, and that the company should calculate and apply a PAF. I respectfully disagree that the company should use a 66 megawatt capacity change for avoided capacity cost. The size of the turbine has little relevance to the change case and the difference in revenue requirements calculation. FERPA allows for using up to 100 megawatt for the change case, and the company's avoided energy, avoided capacity costs, and VIC calculations are based on a 100 megawatt change, which is consistent with FERPA and other utilities in the Southeast. Finally, I would note that LEI uses the cost for a 105 megawatt turbine in its recommendations regarding cost assumptions. Thus, consistency would require using the same size turbine for calculating avoided capacity. I also respectfully disagree that the company should use EIA cost assumptions rather than its own cost data for calculating avoided capacity costs. The costs used by the company are informed by prices submitted by vendors in response to actual requests for proposals issued by the company. These costs thus reflect what DESC itself would have to pay for more capacity. I have a note that Act 62 requires that avoided cost rates accurately reflect the utility's avoided cost, which is not accomplished by using the EIA cost information. I also note in order number 2021-429 regarding DESC's modified 2020 IRP, the Commission directed DESC to use actual bid data for calculating unit cost. I further disagree with the recommendation that the company calculate and apply a PAF. Using construction costs and fixed O&M are sufficient to estimate system capacity value. Using a PAF that artificially inflates capacity values is not needed or appropriate and is contrary to the provisions of PERPA and Act number 62. I further note that the LEI report's calculation of PAF is not correctly applied. Correctly applying the PAF would result in a capacity value of $78.13 per kilowatt year, not $81.99 per kilowatt year as calculated by LEI. I also note that since LEI has recommended eliminating the solar-only rate with its ELCC calculation, a PAF is unnecessary. Finally, I note that although the company respects the work and effort that went into the LEI report, the recommendations I have discussed above violate PURPA, which requires utilities to purchase power from QFs at rates that do not exceed the utility's avoided cost, and also violate Act 62, which requires rates to fully and accurately reflect the utility's avoided costs. I believe that these recommendations do not comply with those requirements and will result in customers paying higher than avoided costs. This concludes the summary of my responsive testimony.
Thank you very much, Mr. Neely. Madam Chair, Mr. Neely is available for questions from the parties and from the commission.
Thank you. Johnson Development Associates.
Madam Chair, Court Walsh for Johnson Development, no questions.
South Carolina Department of Consumer Affairs.
No questions, thank you.
Carolina's Clean Energy Business Association.
No questions from CC, but thank you.
Pine Gate Renewables.
Bland Holman for Pine Gate Renewables, no questions, thank you.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
This is Emma Clancy, no questions.
Office of Regulatory Staff.
This is Chris Huber for ORS. We have no questions for Mr. Neely. Thank you, Madam Vice Chair.
Commissioners.
Vice Chair Belzer.
Commissioner Caston.
Good afternoon, Mr. Neely.
Good afternoon, Commissioner Caston.
I'm trying to better understand this performance adjustment factor, your comments. If I understand what you just went over what was in your testimony, you're saying relative to the PAF, you state that the correct way to do this is by reducing, I guess that would be the nameplate capacity by the percentage, which is in this case is, I think, 5%. So instead of, say, if it was 66 megawatts, that would reduce it 5% to 62 point, well, I got 62.7. I think you had 62.8 or something like that. Rather than the way it is. Elaborate on that just a little.
Sure, I'd be glad to. So the PAF is determined by the forced outage rate of that turbine or that unit, and so it's assumed a 5% forced outage rate, and so what you would get if you apply the PAF correctly, you would reduce the capacity of the unit because you would assume that you would not get the full capacity because it would be forced out some percentage of the time. So that's why you would reduce the capacity. The forced outage rate does not affect the cost of the unit, what you have to pay for the unit. And that's the mistake that LEI made. They increased the construction cost of the unit and the fixed O&M of the unit by 5%. And so that's not the correct way to apply a PAF. Now, my point is you don't really need a PAF, and especially once you eliminate the ELCC, you're not needing to put these turbines on an equal footing with solar because we're not doing an ELCC calculation or if we follow the LEI recommendation. And that's the point that Cersei made in his direct testimony, that we needed a PAF to put the solar on equal footing because we were applying an ELCC. But if you do, and I'm okay with, if we do apply a PAF, as long as we apply it correctly, and that would be to reduce the capacity of the unit. And by reducing the capacity, you end up adding more units in a certain period of time. And that you actually do increase the cost of the plan, but you don't do it by escalating the construction or the fixed O&M costs. You do it by reducing the capacity, which increases the number of units that get added in a certain period of time.
Okay, so if I understood you, and you said you're okay with applying the PRF, provided it's applied correctly as you say, that it simply reduces the nameplate capacity by that 5%.
Yes, sir.
Okay.
I don't think it's needed, but I'm okay with applying it if we do it correctly.
Okay. I have no further questions. Thank you very much.
Yes, sir.
Any further questions? Any Commissioner Williams?
Thank you very much, Vice Chair Belzer. This will come as no surprise to you, Mr. Neely, but it's good to see you.
Good to see you, Commissioner Williams.
Were you, earlier, I think today, possibly yesterday, there was testimony about an order that precedes my being on the commission. And if I got it right, it's order number 2020-244. And we were told, and I followed along and got a lot of the words that indicated that as a part of it, the commission expects and requires a much more detailed and transparent analysis concerning seasonal and hourly value allocation for solar generation in the next avoided cost case. Can you give me background on that? It's my understanding we didn't get the summer data as a part of this. Can you give me your perspective on that circumstance? Because clearly I've heard other testimony.
Right. And so 2 years ago, we said that solar had zero capacity value in the winter, and so it could not help us with meeting our capacity needs. And that's basically our argument. And so we were instructed to be more analytical in our approach. And so we were also instructed in that order to use the ELC calculation to put a value on solar. And so in this hearing for solar, we calculated an ELCC value, or effective load carrying capability value. We provided the program that we used to do the calculation. We provided the input data that we used to do the calculation. Now, there is some complaints about even that information that we provided because we used a SAS programming language to do the calculation, which not everyone understands and can duplicate or even can understand the program. So I understand that everyone may not be completely happy that we've done all that they wanted us to do, but I believe we've met the requirement of that order. And just so you know, we're in the process of transitioning from SAS to a different methodology that will be more robust and will include lots more data. And so every piece of the analytical process should be even more transparent. So I think we've met the order. We've provided the calculations. We provided the program, the input data, but we're continuing to improve our process. And we think that in the future, it'll even be more obvious exactly how that works and what we've done.
Well, that last part especially sounds very good. What I think I heard earlier in the testimony was that summer data was not provided. Can you share more in that regard?
Right. So the need for capacity on our system is driven by the winter, and there's really three factors that cause that. One is the 1,000+ megawatts of solar that we have on our system helps us meet our summer capacity. So most of that 1,000 megawatts will help us with our peak during the summer. Almost none of that capacity will help us meet our winter peak. So that's one reason that the summer is not impacting our need for capacity. The second thing is the reserve margin in the winter is 21%, and the reserve margin in the summer is 14%. So the need for reserves is much greater in the winter than in the summer. And then the third thing is cold weather impacts our loads at a much higher rate than the hot weather in the summer. A very hot day in the summer only adds about 200 megawatts to our load, but in the winter, we could have 500 to 600 megawatts additional load from a very cold morning. So so we provided the data based on the hours that we chose in the winter, and we explained exactly what I'm explaining to you now. Now, I understand that even though we believe that's sufficient to explain why we did what we did, that hasn't satisfied everyone.
Thank you very much for that additional information. Appreciate it. No
You're
further
welcome.
questions.
Any further questions? Any redirect?
No to redirect, Madam Chair. I would ask that the witness be excused.
Mr. Neely, thank you for your testimony today. You may stand down and you are excused.
Thank you, ma'am.
Next witness.
Thank you, Madam Chair. We call Eric Bell to the stand.
There he is. Mr. Bell, can you hear us?
I sure can. Can you hear me?
Yes, we can.
Okay, thank you.
The court reporter will administer the oath.
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Bell, please state your full name for the record.
Eric H. Bell,
And by whom are you employed in what capacity?
Dominion Energy Services as the manager of electric market operations at Dominion Energy, South Carolina.
In connection with this proceeding, Mr. Bell, did you prepare and cause to be filed responsive testimony consisting of 8 pages?
I did.
Are there any corrections or changes to be made to that pre-filed responsive testimony?
No, sir.
Mr. Bell, if I asked you the questions that appear in your pre-filed testimony today, would your answers from the stand be the same?
They would be.
Madam Chair, I would move the pre-filed responsive testimony of Mr. Bell into the record as if given orally from the stand.
Sorry, I'm forgetting now. Mr. Bell's responsive testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. Are there any exhibits attached to your pre-filed responsive testimony, Mr. Bell?
No, there's not.
Mr. Bell, have you prepared a summary of your pre-filed testimony?
I have.
Please deliver that at this time.
Good afternoon, Vice Chair Belzer and members of the commission. My name is Eric H. Bell. I'm the manager of electric market operations for Dominion Energy, South Carolina. In my responsive testimony, I discussed 3 recommendations contained in the independent report on Dominion Energy, South Carolina's 2021 avoided cost proceeding, prepared and submitted by London Economics International. Those are as follows. First, that the company should have a single avoided energy rate. Second, that the Southeast Energy Exchange Market, or SEAM, can be used to minimize the company's variable integration charge. And third, that the company should implement a request for proposal process for procuring new renewable resources. I respectfully disagree that the company should have one avoided energy rate. A separate rate for a solar-only qualifying facility is not the product of technology bias, but a necessary recognition that solar-only QFs allow the company to avoid less costs than other non-solar technologies. This is shown by the fact that solar paired with storage has a higher avoided cost than solar-only, because storage gives the QF a substantially different energy profile by allowing it to control the hours of energy delivery to a much greater extent. I note that ORS witness Ori agrees with the company's implementation of a solar-only rate because using one avoided energy rate would overcompensate solar-only by 7%. Based on the company's calculations, the overcompensation would be as much as 10.35% using the additional modifications proposed by LEI. These costs are real costs that the company's customers will pay. I also respectfully disagree that having a VIC means that there are no differences in the avoided cost of solar and non-solar. The VIC arises solely because of solar intermittency creates the need for increased operating reserves, and more solar on the system creates a greater need for reserves. DES's proposed VIC better recognizes the cost impact to DES customers arising from solar intermittency, and DES solar-only rate accurately values the cost that customers avoid by purchasing all of the output from a solar-only QF. I respectfully disagree with the recommendation that the SEAM can reduce the VIC. Simply put, the SEAM does not provide firm energy resources, which is a necessary factor for allowing the company to reduce the VIC. The SEAM can assist in offsetting the imbalances that result when solar ramps up and down in the mornings and the evenings, and would allow doing so at lower costs than the ramp available on the DES system. But because the VIC results from the need for additional operating reserves, it can only be reduced by adding firm and capacity-backed resources that cannot be cut or recalled. Energy supplied by SEAM transactions is non-firm and can be cut at any time, so SEAM cannot reduce the company's VIC. The SEAM will reduce the cost of balancing the system, but that is not a component of the VIC. Finally, I respectfully disagree with any suggestion that the RFP process should be defined or implemented as part of this proceedings. The purpose of this proceeding is to determine the elements of the company's avoided cost and related matters. Determining the parameters of an RFP process is not appropriate for this proceeding. And this concludes the summary of my responsive testimony.
Thank you very much, Mr. Bell. Madam Chair, Mr. Bell is available for questions from the parties and the commission.
Thank you, Mr. Green. Johnson Development Associates,
Thank you. No questions for this witness.
South Carolina Department of Consumer Affairs,
No questions, thank you.
Carolina's Clean Energy Business Association,
No questions. Thank you.
Pine Gate Renewables,
Glenn Holman for Pine Gate Renewables, no question, thank you.
South Carolina Coastal Conservation League, and Southern Alliance for Clean Energy,
This is Emma Clancy, no questions.
Office of Regulatory Staff,
Thank you. This is Chris Huber for ORS. We have no questions for Mr. Bell. Thank you, Madam Vice Chair.
Commissioners,
Vice Chair Belcher, I do have a question.
Commissioner Caston,
Afternoon, Mr. Neely.
Good afternoon, Commissioner Caston.
On page 3, line 6 through 10 of your testimony, where you say the level of cost that a QF allows the company to avoid depends heavily on the QF's expected energy profile, which in turn varies greatly between solar and non-solar. The DESC production models do not place a value on technology, but instead identify the utility costs that can be avoided by an energy profile without regard to QF technology. So am I understanding that to say that the models that Dominion uses does not consider technology, but not only, but looks at the expected energy profile? Is that inputs in the model? Am I understanding that correctly?
Commissioner Caston, I think that's exactly the way we said it. When we ran the avoided cost, per the allowable amounts in PURPA, we put a 100 megawatt profile around the clock for our time of production, which is our non-solar rate. We ran the model to find the cost of system operations with a 100 megawatt profile around the clock. And that's a nice steady 100 megawatts in every hour. It's very efficient. And when you take that out, you see the cost differential that 100 provides, and then you can examine the marginal costs and the avoided costs And you can create the time periods using that information. And that fairly values a profile that's, much closer to a constant profile. But it does establish an avoided cost in certain hours. But with a solar profile, we have, like has been said before, we have over 1,000 megawatts of solar on the system. And what we do is we take the profile of approximately 20 solar facilities that are on our system that are very much like what we think would be installed next on the system as far as solar-only generators. And those profiles are averaged out, but they're all over time, they're very close to one another, not moment to moment as we've seen in the past, but over time, the capacity factors and the energies are averaged out, and they can be, the profile shows approximately, how much, depending on when the sun comes up, when the sun goes down, and how much cloud cover there is in a month. You get average energies, and we've provided the average profile for that. And what that does is it doesn't provide, energy at night, but it provides a lot of energy during the day, and even more so in the summertime. But that's on top of the 1,000 megawatts that's already there. So it's a very accurate estimate of the avoided cost of that next solar resource, because the model itself, Plexus, it doesn't know what's creating that energy, but it does know, it does have a way of valuing that profile exactly.
Okay, so again, what I'm hearing is that the model, Dominion's model, is technology neutral, and it simply looks at when the energy is being produced and when it's not.
That's correct.
Okay. No further questions. Thank you.
Oh, you're welcome.
Any further questions? Any redirect?
Madam Chair, no redirect, and I would ask that the witness be excused.
Mr. Bell, thank you for your testimony today. You may stand down and you are excused.
Okay, thank you.
Next witness.
Mr. Willoughby will be calling the next witness, Madam Chair.
Thank you. Mr. Willoughby.
Thank you, Madam. Yeah, thank you, Madam Chair. We would call as our final witness Mr. Peter David. Mr. David, I see your camera's on, and we'll test your mic here in just a second. Madam Chair, do you wish to swear the witness at this time?
I think Mr. David was sworn yesterday, was he not?
He was. That's exactly right.
Mr. David, good. You are still under oath.
Understood. Thank you.
Thank you.
Mr. David, for the record, my name is Mitchell Willoughby on behalf of Dominion Energy South Carolina. For the record, what is your full name?
My full name is Peter B. David.
And in connection with this proceeding, Mr. David, have you provided direct and rebuttal testimony previously in this case?
Yes, sir, I have.
And are you appearing today to sponsor and present your responsive testimony in connection with this proceeding?
Yes, sir, I am.
And let me pull it up here. And I believe your responsive testimony, Mr. David, it consists of 8 pages. Is that correct?
That is correct.
If I asked you the questions that appear in the responsive testimony, would your answers today from the stand be the same?
Yes, they would.
Madam Chair, we would move the introduction of Mr. David's responsive testimony into the record as if given orally from the stand.
Mr. David's responsive testimony will be entered into the record as if given orally from the stand.
Thank you very much, Madam Chair. Mr. David, have you prepared a summary of your responsive testimony?
Yes, I have.
Please deliver that at this time.
Good afternoon, Madam Vice Chair and members of the Commission.
My name is Peter B. David. I'm an associate director in the Energy Sustainability and Infrastructure practice for Guidehouse, formerly known as Navigant Consulting Incorporated. In June of 2021, Guidehouse completed a study titled Variable Integration Cost, the study, on behalf of Dominion Energy South Carolina Incorporated, DESC, or the company. In my responsive testimony, I discussed recommendations in the independent report on DESC's 2021 avoided cost proceeding, prepared and submitted by London Economics International Incorporated, the LEI report, regarding the variable integration charge, VIC. At the outset, I respectfully disagree that the Guidehouse study is not a truly independent study. Although DESC provided data on the operating parameters for its generating assets, the remaining inputs were developed independently by Guidehouse. Also, all modeling and calculations were done by Guidehouse, independent of any direction from DESC. I would note that Guidehouse is the only party to have conducted a VIC study for integrating solar capacity into the company's service territory. Additionally, I respectfully disagree with the suggestion put forth in the LEI report that the number of disagreements regarding the study support the need for another independent study. Parties representing solar developers have a vested interest in arguing against any VIC that is greater than $0 per megawatt hour. Expecting substantial agreement about the VIC across all parties is an unrealistic standard. Rather, the question is whether the Guidehouse study is independent and reasonable, and for the reasons I've explained in this proceeding, it is. I also respectfully disagree that continuing the current interim VIC of 96 cents per megawatt hour subject to true-up would be the best approach. As I have previously discussed, the Guidehouse study is an independent study, and there is no reason to reject it until such a time as some other independent study can be performed. And although company witness Cassis did state that DESC would be willing to accept the continuation of the current interim VIC subject to true-up, he did not say that continuing the current VIC is the best approach. I do further state that if the commission concludes that continuing interim VIC violates Act number 62, the company's proposed VIC of $1.80 per megawatt hour is not only a reasonable value, as agreed on upon by both ORS witness Horry and LEI, but the only value calculated through a rigorous analysis presented in this proceeding. I also note that the LEI report does not address Guidehouse's proposed VIC of $3.43 per megawatt hour for Tranche 2. Guidehouse strongly believes that the calculated value of $3.43 per megawatt hour for Tranche 2 is reasonable and appropriate. Finally, although the proposed SEAM can provide measurable benefits to the company's customers, I also do not agree that it can be used to reduce the VIC. The VIC in this instance is based solely on the increased minimum operating reserve requirement needed to integrate solar capacity. Operating reserve requirements are based on firm energy expectations, and only firm resources can provide operating reserves. Because the proposed SEAM is a market specifically for non-firm resources, it can neither impact the company's operating reserve requirements nor the resources that can provide operating reserves, and therefore it cannot impact the VIC. This concludes the summary of my responsive testimony.
Thank you very much, Mr. David. Madam Chair, the witness is available for questions from the parties and from the commission.
Thank you. Johnson Development Associates?
No questions. Thank you.
South Carolina Department of Consumer Affairs?
No questions. Thank you.
Carolina's Clean Energy Business Association?
John Burns for CCBA. We have no questions.
Pine Gate Renewables?
Bland Holman for Pine Gate Renewables. We have no questions. Thank you.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy?
Ms. Emma Clancy, no questions.
Office of Regulatory Staff?
This is Chris Huber for ORS. We have no questions from Mr. David. Thank you, Madam Vice Chair.
Commissioners? Questions for this witness? Hearing none, I assume there's no redirect? Not allowed?
Madam Chair, I'd love to do some redirect. I just don't know what question I'd be responding to. But thank you very much for the opportunity.
Mr. David, thank you for your appearance and testimony today. You may stand down and you are excused.
Thank you.
Thank you very much, Madam Chair. That concludes the witnesses for the company. There was a question about closing statements to be made, and that's
They were.
still,
That's still up in the air, and as I mentioned yesterday, we needed to conclude before 4 p.m. today. So my recommendation, and I will hear from the parties if there are objections, I would propose that we recess for this afternoon and we reconvene at 1 p.m. tomorrow to hear closing statements from the parties. Is that problematic for anyone? I will advise that I know in previous cases we've had a 5-minute limit on statements. This has been a lengthy case. There's been some time between the portion heard in August and this week. Therefore, I will limit those arguments to 10 to 12 minutes, and I'll have my clock set.
tomorrow afternoon works for Dominion Energy, South Carolina, Madam Chair.
Thank you.
Works for CCBA as well, Madam Chairman. Thank you.
Thank you.
No objection from Pinegate. Thank you.
Thank you.
No objections from the Department of Consumer Affairs. Thank you.
Thank you.
No objection for RS. Thank you.
Thank
Yes,
you.
it works for CCL and SACE as well.
Thank you. Hearing no objection, and we appreciate all the witnesses' appearances this week, and as well as counsel, and we will recess until 1 p.m. tomorrow. Thank you very much. Have a good evening.